Priyanjali Urvashi, please mute yourself.
Sorry?
Priyanjali Urvashi, please mute yourself. Both of you.
Okay, perfect. Sorry.
We are live.
Ask sir to join. We need to start.
All right, I was able to get in from here. Is this better?
This is
Yes.
superb. This is so much better.
Superb. Just give me 1 second. I'm going to leave the other office now.
Anjali, the light is not coming. Put up piche.
All right, all ready?
Yes, you're live. We should start now.
I'm ready. Yeah.
Anjali,
Hello, good afternoon. Hello, everyone. Good afternoon, and welcome to our weekly webinar. I am Anjali, your moderator for today, also heading the sales and marketing for My Legal Software. My Legal Software is a legal case management software, and today is Thursday, September 15th, and we are going to talk about a very interesting topic today, ethics and disciplinary actions against attorneys before the grievance committee. As a guest speaker today, we have with us a principal attorney at Gehi and Associates, Mr. Naresh Gehi, who is a highly experienced immigration and corporate attorney in New York. And his firm has 80 members worldwide and is growing rapidly. Mr. Gehi has served as a personal advisor to the president of Suriname and is the founder of My Legal Software, where he has served as a mentor and a trainer. He's also a cited expert for the Fox News, Pix 11, Reuters, and has been cited as an expert and a speaker at New York Times, New York Post, Mother Jones, and several other publications. We also have with us Mr. Joseph F. DeFelice, who is a former counsel to Grievance Committee. He's a former attorney with the Department of Homeland Security, Law Secretary to Supreme Court Justices and Assistant District Attorney in Queens County. He has served in Grievance Committee for 8 years. Mr. DeFelice represents clients in New York's criminal, district, county, and Supreme Courts. He has successfully handled trials and appeals in civil and criminal cases involving DUI, DWI, domestic violence, homicide, and drug charges. I'll give a couple of minutes to our speakers to let us know about their experience today in the webinar.
Yes. Anjali, if you could come live, that'd be great because you were kind of blanking off a bit, but thank you for being back. So it's my pleasure and honor to introduce one of the finest people that I've known in my career. And this gentleman is no other than Joseph DeFelice. He has been the former president of Queens County Bar Association. And I'm sure you all know how prestigious that position can be. You have to be a man of integrity. You have to be a person of respect, and you should be well known amongst your peers. And besides that, he has also served. I just want to correct Anjali a bit, and I want to make it clear that he has served on the grievance committee for a period of 8 long years. Now, what does that mean to all of us? That means that he's seen different kinds of cases that come before the grievance committee, and those cases may be immigration cases, they may not be immigration cases. And also, what Joe also does is that he represents people, who have trouble before the disciplinary committee in New York. So I'm going to kind of ask my wonderful friend Joe to come in and join us and talk to us about, a little bit about him. And then we are going to begin our question and answer session. And I'll be asking a lot of questions to Joe, and Joe will be replying back. And if you all have any questions, you can just start sending it over to us and through our wonderful moderator, Anjali. And I need to thank Urvashi and Priyanjali for joining us today. Welcome, Joe, and let's get started with you. And it's a pleasure having you today.
Well, thank you very much, Nadish, for those kind words. And I want to thank My Legal Software for sponsoring this webinar. They have produced a very good product, which if you're interested in obtaining software for the immigration use, it's certainly one product to look at in making your determination. In fact, you should have some product like that when you work in immigration because of all the forms and that they have with the immigration courts, and you're able to keep up to date with the new forms as they're put out by the service. Anyway, as Nadish said, I was on the grievance committee for 8 years, and we got to review many different cases. And one of the questions that I was asked to answer was, what kind of cases come before the grievance committee? What should you look out for? Well, what do you think causes problems when you're a lawyer? All right. Sometimes it's the simplest things where clients get upset with you because maybe you didn't answer telephone calls. You've made several phone calls and you didn't answer. Or sometimes you make a mistake and you don't go to court when you're supposed to go to court, and the client's case gets prejudiced in some fashion, okay? I mean, those are basic things that we all know about and can cause actually a grievance. And if you get a letter in the mail from the grievance committee, you know, your heart will start to pump because you don't know what it is. Many times clients will, you know, prepare some letter and send it to the committee, and they automatically have to send it to you. They send it to you. Well, there's one exception. If the case is like totally ludicrous or the argument has really no basis in fact on its face, they actually dismiss it and you don't even know about it, okay? So people could file complaints about you that you don't even know about. But for the most part, the cases come before the committee and there are attorneys that are paid by the state that work on these committees, and they review these cases. And if they feel that there's some substance to it, what happens? They send you a copy of that letter. And they ask you to reply usually within 10 days. So now keep in mind, and don't be afraid, you can always ask for an adjournment of time. Ask for additional time to answer those papers. And they will grant it to you, but just don't abuse it, okay? Some lawyers feel that they never have to answer and they keep asking for adjournments. So that's one thing you want to be concerned about. And the next thing is, should you answer the papers on your own, or should you hire a lawyer to respond to these questions? And I would advise you to always at least consult a lawyer, all right? You could probably consult with a lawyer with a basic fee, or maybe a courtesy if it's someone that you really know that's knowledgeable in this area, and see what should be done. But you know what they always say, if you represent yourself, you have a fool for a client. So you got to be careful. And everything that you say in that letter can be used against you. And everything that you say in that letter could wind up, you know, putting you in a position where you can't refute things. It's almost like going into the grand jury. You know, when you go into the grand jury, you give testimony and you're sort of locked into that testimony. So you have to be very careful in what you say. And the most important thing is to be totally honest. All right? Because if you're not, that's going to be a big problem. And that's another basis for another grievance that they can file against you. The committee will do that, right? And we had a case one time where they were going to charge this person with some kind of disciplinary action. And he was swearing that he had sent money back to the client by certified mail. And they weren't believing him. And in fact, it was me. I suggested, why don't you ask the lawyer for the receipts from the certified mail to see if he's telling the truth? And sure enough, he had those receipts and his case was dismissed. So there's a big difference between having your case dismissed and having your case go to the Appellate Division, especially if you have some kind of a record, okay? Nowadays, years ago, you used to have a case either dismissed or dismissed with an advisement, or you would get a letter of caution, or you would get an admonition, or an admonition personally delivered. In other words, that was an admonition where you would have to show up by yourself or with your lawyer, if you had a lawyer, and they would basically scold you in front of the committee. Do you hear me?
Yes.
Yeah.
Yes.
That would be, they would, and it's embarrassing besides other things. Or they would send your case to the Appellate Division, and the Appellate Division can do a number of things. Number one, the Appellate Division could send the case back to the committee and say, well, we feel it should only be an admonishment. Or they could issue a censure, a public censure, or they could bring charges against you to suspend you or disbar you. And while all that's going on, you usually have to appear before a referee, who's usually a retired judge, and they take testimony. And boy, if you don't have a lawyer by then, you better get one, okay? And back when you first start, when the first complaint comes in, when they do an investigation, they can have their own depositions too, before they report to the committee. In other words, the complainant would have charges and they would call you in for a deposition. You would be sworn under oath and they would take testimony and evidence. And that's how they form the basis of their report that they submit to the committee, which is what I served on. And they would, we would vote as to what should happen, to that person. Nowadays, they cut back on what they can give you. Nowadays, it's either an advisement with dismissal or an admonition, or you go to the Appellate Division, and nobody wants to do that, all right? So what about immigration, I guess, right?
Yes.
We're talking a little bit about immigration today. All the same things that we complain about in any other case can form the basis of a sanction or some sort of a grievance against you. You could forget to file a notice of appeal. You could not tell your client, and I think there's materials that were submitted with this, and you'll see that in the materials. You cannot tell your client about some important factor, or you might not file certain papers or petitions that your client's entitled to, or fail to tell your client of an adjourned date or a date where they have to appear. We had one instance with these WebEx things here. Now immigration is doing a lot of trials on WebEx. And we actually had a client, lawyer who he tuned in to the wrong judge. Each judge has their own little site. And by the time he figured it out and went to the right judge, it was 20 minutes past the time his client was supposed to be there. And his client was there and all the witnesses were there. And the judge had already ordered his client deported. Because or if you don't know, I'll tell you, when you don't appear at the immigration proceeding, either a master calendar or an individual calendar where they're going to take testimony, the judge can order you deported. Okay. And that attorney, they had to make a motion. Fortunately, they made a motion to reopen the case based on the facts. I mean, I think that the other judge probably talked to the judge who had to make a decision and told him, yeah, he was in my part, you know. But that's one of the things that can happen. And you got to be careful. All right. And of course, you always have to be careful about money, keeping an accounting of the monies. And that leads us, I guess, into retainer agreements. Retainer agreements under the law in New York, if your retainer is expected to be at least $3,000 or more, you should have either a letter of engagement or a retainer agreement. Okay. And that should spell out what your services are going to be. What am I going to do for you? Okay. And you tell your client what you're going to do for X amount of dollars. All right. You could have a minimum fee. Okay. You can't have what they call non-refundable fees. What did I want to mention on that? Oh, and one of the other things, and it's sort of embarrassing to even talk about this, but in divorce cases and in immigration cases, okay, one of the things that can lead to a grievance is if you become personally involved with your client. And that goes for the male attorneys as well as the female attorneys. I've seen it on both ways. Okay. If you become personally involved, domestic relation cases and matrimonial and immigration cases, there's special rules here for the Appellate Division, and you can be severely criticized and a grievance can be brought against you. Now, one of the things we talk about is Lozada, okay? That's a big name in the immigration field. And that's matter of Lozada, 19I&N decision. And it's, I believe, 637. It's a 1988 case. And they basically said, hey, look, if the lawyer has done something wrong and you want to make a claim about it and try to reopen your proceedings, and when I say wrong, I don't mean, you know, it could be just negligence, then you must file a complaint with the grievance committee. Now, let me tell you, because I was on the grievance committee, they know about Lozada. And they know that sometimes people make complaints and they make things up, okay? So that's something to know, that at least people on the grievance committee know about that, and they take some of these things with a grain of salt. But as a lawyer, you should have your records. You should keep good records, letters that you send to clients, or any other thing, or, you know, copies of your paperwork, etc. And even if you did research and you have cases that maybe you printed out, that's going to help you too, and to show what you've done and what was going on. That's to defend yourself. But if you're on the other end, if somebody comes to you and you feel that, yes, there has been something that you can raise before the immigration committee about the other lawyer, then you have to tell your client to follow through with Lozada and file a complaint. But now in 2020, another case came out, and that case is matter of Melgar, Melgar, and that's 28I&N decision 169, Board of Immigration Appeals. Both those cases are BIA cases. Now, what Melgar did was expand and explain more on Lozada. So check this, if you got a pencil, this is what you have to do. There's 4 or 5 things that you have to do. Number one, when you make your motion, you have to state what the agreement was between the respondent, alien, and the lawyer that you're complaining about. What was the agreement? Number two, you have to inform that attorney that you're making this claim and what it's about. And you have to give that attorney's response. If that attorney responds to you, if he doesn't respond, you say he didn't respond. I told him this and that and the other. He didn't respond. But if he responds, you have to include that in your motion. And you're also going to have to serve him with a copy of your motion. And then you have to tell the judge, the immigration judge, if you actually followed Lozada and filed a grievance complaint against that person, okay? And if you did not, you have to state, why wasn't that done, all right? And you have to have a good reason. And number four, you have to show prejudice to your client. In other words, what this lawyer did has prejudiced your client. And number five, you have to show that if it wasn't for this factor, there's a reasonable probability that your client would have prevailed in the matter, okay? If you win, they're supposed to, according to Lozada, put you back into the original position you had at the time of that negligence, all right? So those are the things you have to do. In reference to that. Let's see. There's a number of other things. You know, immigration is a little different than the other fields because sometimes the courts are going to look at you or look at your client because they know that the client is usually somebody that's from another country, may not speak English as well, and they hold the lawyers to a little bit of higher, you know, classification.
There's a case law on that actually, Joe. The case law on that is Aris versus Bukassi, 517 F3D 595, Second Circuit. So that says that immigration attorneys are often de facto held to a higher standard of competence and care. So this means immigration lawyers should not take immigration lightly because you're not going to be judged by the reasonable standard, but you're going to be judged by the higher standard, especially because if a person gets a deportation order, then they're looking at serious trouble if the client had some form of relief. What would you say on that, Joe?
Yeah. Yeah, well, you know what? Now that you mentioned that case, I remember that immigration has its own grievance committee.
Yes.
You could be, you know, they could file grievance against you and you can be suspended or removed from, but, you know, actively handling any cases before the immigration courts in the whole country. So that's a very serious thing. And I've had some attorneys who were clients of mine who had certain issues like that that came up. And sometimes we like to see what the issues are and how we're going to respond so we can protect those people and not have their license or removed or some kind of complaint brought against them, you know? So those are factors that could come up with the immigration court.
So, Joe, I have some questions to ask you, and this is something which I'm seeing in the immigration world. So we'll also go to talk about the common issues which are faced by lawyers and how they should come and how they need to respond. So number one is that I feel what happens sometimes is that there are clients and they just trouble you for no apparent reason and they just keep bothering you. And even if a case gets denied, sometimes they blame the lawyer and they file a grievance. So my recommendation is that, as you rightly said, that a lawyer who acts for himself is a fool for the client. When you get a grievance complaint, and especially if you're in New York, I would strongly recommend you to get in touch with Joe DeFelice. And Joe, what's your number, please? What's your phone number?
718-261-3358.
So it's 718-261-3358. And your website is?
DeFelice Law
It's DeFeliceLaw.com. And I would say that anyone who has a grievance issue, especially I'm talking about New York, and I'm sure that he can represent people who are in the state of New York and who have grievance matters. Am I correct on that?
Yeah. And one thing now that you mentioned that, another thing on the Melga case, they mentioned that you can't, suppose you're the lawyer that made the mistake, okay? You cannot make the motion to reopen. You can't, and there was a lawyer that did that, and that was, they denied it. In other words, you can't fall on the sword and say, hey, I made the error, I'm sorry, I made the mistake, and now, I think, in fact, that was the Melga facts, where they say, I made the mistake, and please reopen the case because I was negligent. And you don't even file a grievance.
Oh my God.
Because you don't file a grievance against yourself.
Right.
So that's a conflict of interest. And also the court said they're suspicious of those kinds of things because they feel that the client and the attorney might be in some kind of a conspiracy after they saw what the error was and try to bring the case back and, make that misrepresentation. So your client has to get a different lawyer.
You have a question on this too. There's something known as a scrivener's error, as you know that, because you know what's a scrivener's error, wherein you make a mistake on a brief and sometimes you go back to the court and tell them, I'm sorry about this error that happened inadvertently. So if there is an inadvertent error and if a lawyer missed something, then how should he address that issue?
You're talking about before the grievance committee?
No, even if suppose in case you filed a case and you forgot a form of relief. And, those things happen with new lawyers, especially. What they do is that, I'll tell you a simple real life example. In a case wherein a person was in immigration hearings and he was fighting the asylum case, but he did not know that he had a fantastic case for cancellation of removal because the wife was a US citizen in this case, and their children over here. He was trying to go for adjustment, and the person was not adjustable because under 245, he was not eligible under 245A. So he argued before the judge that I'm adjustable and everything. And I know that he had issues with those cases. How should a lawyer handle these issues? And what would be, the perspective of the grievance committee in such cases?
Well, technically, there are cases where if you fail to make your application, you're going to have a grievance against you. You could be punished in some way. I think in these cases, the attorney might be well advised to explain his background, okay? Especially if he's a young attorney that hasn't practiced very long, and explain how he made a mistake. And, the grievance committee itself, is not necessarily going to suspend him or suggest that it go to the Appellate Division for that reason. I mean, immigration might hold him as negligent, okay?
Right.
But the grievance committee in the state of New York, and again, it's always going to be based on the facts. I think that kind of case, especially if the attorney doesn't have a record, they look at his record, previous record, probably he's going to get away with some sort of minor violation, and it won't go to the Appellate Division for that.
Right.
All
So,
right?
yes, a couple of things that come to my mind, which is very important for lawyers. The most important things, this is the basic canon of professional ethics, even under the model penal code, under the model code, it's, and also under New York, basically code of ethics, is diligence, communication, and loyalty. So as you see, the importance of the word diligence means once if you get the case, start working on it right away. Don't wait until the last minute. Rule number one. Because that can get you into the problem of neglect if you just neglected it and the client lost a relief. That happens in H-1B visa cases sometimes, that you did not file the labor condition on time, you did not do anything, and the guy even lost a chance. That's number one. Secondly, when you're dealing with individual hearings, be very careful, because the courts, even the judges, have timelines, and therefore it's very important for lawyers to read the EOIR manual very carefully, and even the BIA manual. That's like the ABCDs of practicing immigration law. If you're not reading that, I think I would strongly recommend you to open the manual and read it carefully. Then thirdly, remember one other thing which I've seen from my practical experience. Some judges have a requirement of written pleadings. So make sure that you're ready with the written pleadings, otherwise the judge is going to be upset at you, and he's going to tell you that, you know what, why don't you read the law? Now, in a lot of these cases which I've seen, when lawyers are appearing before the court, what I've seen is when they appear, they don't even know what relief to ask for. And be very careful when you're asking for the relief of voluntary departure. And I'll tell you why. Because take an example, there are a lot of case laws on the point, and end of the day, you appeared before the immigration judge. This person entered with a visa, and after he entered with the visa, he's telling you that, hey, listen, I'm just about to get married, and the judge made a decision at the individual hearing that you're going to be ordered deported or take voluntary departure. Be careful before you accept voluntary departure. You know why? Because there are case laws while the case is pending before the BIA. And if you get married, the leading case on the point is Velard Pacheco, which I have everything on the back of my head. Through Velard Pacheco, you may be able to get a remand, and the client would have been able to adjust. So immigration law is very tricky. And here you accepted voluntary departure, and then after that, you're closing the door because he cannot ask for relief for 10 years now. So be very careful, read the law carefully. And as I'm saying, immigration lawyers are being judged at a very high standard. Joe, your comments on this issue.
Yeah. One thing I wanted to mention on that also, what you said about reading the rules of the court, is that most of them want 30 days in advance. Okay. Some judges will give you 15 days in advance to have your evidence in. And I noticed this with the government. They make motions at the last minute for permission to file late. And I filed on 1 or 2 cases. I filed the government. I said, well, I want to file late too. And I was granted.
Oh, you were granted. Well, you had a good judge, because end of the day, the government, I don't know what the rules are, but I believe they should be also kind of, some judges hold them to a high standard too.
Yeah, but that's, I've seen the government do it. So you can always try it, you got nothing to lose. If you feel that the evidence is important for your case and somehow wasn't sent in earlier, so those are the things that you have to look
and a few
for.
other important things which I'd like to cite. Citations are very important in the session. And also, as you can see, I'm so happy to have Joe DeFelice, and he's a wonderful man. And I think, God forbid, if you get into an issue with the grievance committee, especially in New York, he's the person I would recommend you to talk to. And he's also going to be a speaker in future. And he's going to, since he's so good in criminal law, and he just mentioned that we want him to come and talk to us about aggravated felonies and his experience with aggravated felonies, of how he deals with the courts in New York and how he gets those wonderful, kind of deals with the government, and he avoids aggravated felonies. We're going to talk that about, about those issues in future. But some good defenses, Joe, that may help lawyers. So number one is ineffective assistance can also arise from an attorney's failure to ensure that the clients remain eligible for a particular form of relief. So always remember that even if your client is eligible for a DACA, make sure you advise them that you're eligible for a DACA. Don't just nap on the case and say that I was retained for so-and-so. You should try your very best to make sure that, the issue here is that exactly that you are eligible for a form of relief. So I think, Joe, you have a question here. So you can answer that question, then I can take it.
Let me see the whole question.
All right.
Let me say, the question is, what happens if the complaint is dismissed after a reviewing committee hearing? Well, that's a good thing. I mean, your complaint is dismissed. That's a good thing for you. I guess you mean what happens to your immigration case.
All right.
I think that you still would have a viable case because under Lozada, you filed a complaint, okay? And whether or not the grievance committee feels that there should be some kind of sanction might not necessarily be the same rule that the immigration or, USCIS is Department of Justice is going to follow. All right.
Right.
So I wouldn't say that that you're dead in the water as far as immigration is concerned. Okay. Obviously, I had one case where we showed that the attorney was disbarred. So that was a good thing for my client. It wasn't a good thing for the lawyer, but it was a good thing for the client, and it made his case stronger, But
I
it was
remember-
disbarred for a number of different reasons. And sometimes they get into that too. Like,
Right.
see what happens is in an immigration, especially in immigration, we've seen lawyers doing the wrong thing in a number of cases, not just one case. So this lawyer that I'm thinking of with disbarred, he had a number of cases that he was doing, the wrong thing. He was telling the clients that he filed motions when nothing was ever filed. And that's just a recipe for disaster.
Disaster, right?
Yeah.
Joe, remind me of a few things that people have to know. If you remember, I'm not going to take names. There was a lawyer before, this is before when the Life Act got passed. He took up numerous applications and he took people's monies and everything. And he was caught in Canada and he was even jailed. He was brought back to the United States and he was serving time in jail. So be careful that when you're doing a major fraud, you can also go to jail, especially if it's a criminal fraud. If you remember
That
I
happened.
don't want to
But
name the lawyer.
There's a question here, but first let me, before I address that question, just on what you just said, I'm aware of a case here in New York where the attorney had 3 set stories for his Chinese clients, women, about how they were abortion, because of the one-child rule that China used to have back when, okay? And he had 3 rules that he was following, fact patterns, exactly the same fact patterns, okay? And the clients who had their cases approved eventually had their cases, disapproved and green cards
Oh,
withdrawn.
yes, we've seen that.
And the attorney and even, I think, a paralegal wound up going to jail, okay? So
Right. Yes.
it's not a good thing to do that,
Right.
and you got to be careful. Let me
Now,
see.
Joe,
There's
there's
one
something
question.
new.
Yeah.
Sorry, this is so important that I have to stress on it before we take a question. Now, there's this new thing which I've seen about something that came to me is husband and wife were married or something, and they had an entry issue. So the lawyer told them to file a battered spouse so that he doesn't have to leave the country. And he charged them a huge sum of money because the guy didn't want to leave the country. I was very upset. A lawyer should not be circumventing the law in order to get a relief in such cases, because you're looking at over here, you only have to charge a reasonable fee, number one. You cannot charge an exorbitant amount of fee. That's number 2. Plus, the client did not even know in this case that that a battered spouse application was being filed. So what would you like to say on such cases if they come before grievance?
Well, if there is a VAWA, if it's a legitimate VAWA.
It's
claim-
not a legitimate VAWA. They're
Oh, well,
living
that's
together.
another story. You can't do that. The same thing with asylum cases. If you file a frivolous asylum case and they rule it's frivolous, I believe it bars you from any other relief.
Right.
So you have to be careful what you're doing for your client. Let me see, we got one question here. What happens if the grievance panel decides that there's probable cause of misconduct? Well, what happens, you mean with the immigration case? Like I said, with the lawyer that got disbarred, obviously it made that respondent's case a little stronger. And what happens with your case if you happen to be the lawyer guilty of misconduct? Well, anything can happen. They can just give you an admonition. It doesn't mean that you're going to be sanctioned or gone to the Appellate Division. It depends on various factors, and it depends on your record.
And the gravity of harm, that's the test which is applied. The gravity of harm and the amount of misconduct that the lawyer
Right.
has caused in the case.
And what if my complaint is about fees? Usually, we look at that as a fee dispute. And you are supposed to have in your retainers, I think it's 137 of the rules.
137 of the rules, yes.
Yeah, that you could go to arbitration on that. So if it's a fee dispute, they're not really going to look for a grievance unless,
Correct.
as Nadish said, unless it's like a really absorbing
Excessive fee.
excessive fee.
So I'll take the next question. What is the importance of case notes, case records, etc., in disciplinary proceedings? That is golden, because that is actually your business records under the rules of evidence, under the federal rules of evidence, and that can be used, and keep very good records. And I use my legal software for that, of course. Like, I'm the founder, let me be open about it. But I make sure that, if anyone has that issue, I would tell them to make sure that you have detailed notes, because those notes take you a long way. Communication is the key when you're dealing with the grievance committee, according to my friend DeFelice. And secondly, be honest before the committee. Mistakes happen. What I've seen is when you're honest and upfront, you can come out of the problem. But if you try to lie before the grievance committee, you're looking at a serious, serious problem. This happens when people act on their own and they don't go to good counsel when they fight those cases. Joe, your comments on that?
It's an obvious thing. I think I had mentioned that you have to keep good records to protect yourself sometimes. It's, it's cover your own behind, so to
Right.
speak, So if you made phone calls to the clients, if you filed letters, it's good to send letters. We get the
Right.
notices and we send letters out to the client. Your hearing is on such and such a date. You've got, here's a copy of the notice for you to go to get your biometrics. You have to go to Jamaica or whatever the address is. Okay. And we give them the notice.
Yeah, I think Anjali has to say a few statements about how she's feeling about the viewers. Anjali, please say a few words, then we can take some more questions and we'll be back. Anjali, the floor is on to you.
Thank you so much, sir. So actually, we were all enjoying the session so much. And if the audience, whoever has joined us recently, I would like to mention that if you're a lawyer, an experienced lawyer, then you can also have an opportunity to speak and be a guest speaker at our webinar. You can mail your resume and your details to us at legalquestions@mylegalsoftware.com. We can have a look at your resume, and if you qualify, you would be invited to be one of our guest speakers. And we'll be informing you whatever the input would be. Also, sir, it's such a great session. Also, I could relate so much about my legal software here, like you were talking about master hearing, individual hearing. So we have different types of events with us. You also talked about case notes, records. So we have a proper documentation management. We have a proper case note strategy. And we also have client management. So, I mean, I could relate so much to the sessions. I'm sure our lawyer friends are enjoying the session. And we have so
Thank
many
you. I use the master calendar and the individual calendar, but it's for people to test it out on their own. We are not here to kind of play favorites, but people should test it out on their own with you, and they can schedule a demo with you and they can call your number. But I'm very happy with the software for the firm. And I mean, I've been using it and I'm pretty much happy with everything. So Anjali, what's the next thing you'd like to say?
Sir, I think, sir, the session that we are continuing about, grievance committee and how the immigration cases are related to it. We also have a couple of questions from our people. Like they want to know, is it recommended to retain a lawyer to a grievance?
Now, let me answer that. According to me, with due respect, I think if anyone gets a grievance letter, because I'm not a grievance attorney, let me make that very clear. I'm a general counsel to my practice. I'm exactly the principal of my firm. My recommendation has always been, once you get it, go to a person like DeFelice, because they know what they're doing. They've seen both the sides of the aisle. There's a big difference because you may see that from your perspective, but you cannot see it from the other person's perspective. So Joe has all this great experience. And, also what we are planning on doing is that if a person is a speaker, we'll be putting up his profile, or, I believe you said you want on my legal software. So also,
Yes,
this is also going to be available over there. first thing is that, as Joe said, when you get the grievance letter, first thing is you get a stipulated amount of time, around 10 days to answer it. So look for a lawyer and get your records in order. And what you should do is you can keep your entire story in order. So it's easier for a person like Joe to look at it. What is your defense? And I would follow the 5 W's of journalism here: who, when, where, what happened, when you met the client, whether you have a retainer. I cannot stress the importance of the retainer in these cases, because you are actually making clear about your duties over here. Sometimes clients accuse you for duties which are not in your retainer. A good retainer is the first defense, first line of defense. Second is your communication with the client. And thirdly, your case notes, as you said, that's what I use. When I even call up a client, he does not pick up the phone. I make a note and date of that on my legal software to make sure that I am protected. Because the client may say, hey, listen, I never got a call from you, lawyer. You called. And one important thing which I would stress is very important. Please, folks, close your files. Now, the client has not responded for 6 months. Let them know this is one mistake, Joe, which is done by lawyers, is that they do not close the file. Send the file closing letter, because if the client does not respond, that is the best way to protect yourself. Because if the client is going to come back after 3 years and tell you, hey, how come you did not follow up on my H-1B? Sir, I wrote the letter to you. I emailed it to you. I sent it by certified mail. See, what Joe said is very important. Try to send mails, for certified mails, because your client may come back, your kind of, your aggrieved client may come back and say that I never got the letter. So send it by certified mail, send it by email, return phone calls. And there's another important thing about that you can kind of take it as a defense in grievance matters is, number one, due diligence, that you did your due diligence. Secondly, you took a strategy which was better for the client. So for example, you went before the immigration judge and you felt that the client is from Europe. You did not apply for asylum because you'd seen that the country conditions were not good, but he got married and you applied for his green card straight up there. That was a better strategy, because he may say, why didn't you apply for asylum? Because, sir, I looked at the country conditions and I don't think so. The judge would have been upset and the judge would have sanctioned you as a client. So, having a great legal strategy and making sure that you explained it to the client is important. Another important thing with Joe, which I've seen, sometimes this is where lawyers miss. A lot of lawyers miss it. When your client tells you to do something and you're not comfortable doing it, withdraw from the case. Sometimes it's a good idea to return the money to the client, give him a partial refund and settle the case, because prevention is better than cure. And the client will tell you, give me the money back. And when you are returning the file, when another lawyer is asking you, do you know it is your ethical duty to give the file to the lawyer, otherwise you can face a grievance for that? Always send the file to a lawyer. Another reason why lawyers get into trouble, these are things which Joe hasn't mentioned because we both had this plan to give the full 360 today. Another major reason why lawyers get into trouble, because you cannot threaten another lawyer for a grievance. That's one mistake I've seen. When lawyers pick up the phone, they tell them, I am going to report you to the grievance committee. This is a big canon which I tell lawyers to be careful about, because threatening another lawyer is a grievance by itself. There's case law on the point, Joe. And I'm sure you know that very well on this, Joe.
Yes, that's very true. That's very true. I was looking at some of these questions. Somebody asked, is it advisable to retain a lawyer at a grievance committee? Yes.
My answer is yes.
I would say yes. You're listening to what I said. But of course, you always have the right to do that or not.
But I think a lawyer who acts for himself is a fool for the client.
Yeah. Do you want to answer any
especially when you're dealing with
questions,
grievance.
You want me to go through them all, or?
Yeah, I think you should go through them.
Okay, I'm going to go through them all. All right. Let's see. What was the next one?
So next one for you.
That's for you.
About ML, about my legal software.
So
Right.
the question is, how can
I would say yes. It's very good to have that kind of a software, because when things come up, you're going to have everything on the computer. If you just have it on paper, sometimes, in your office, things can get tossed aside, misplaced, misfiled. And and for budget reasons, it's also better to have these things on the computer because eventually you got storage issues. So yeah, if you have a software like this, you're going to see all the forms that you've been filing and what you've been doing. And you'll be able to have a nice, clear record. And also, it's something that you can present to the committee. Here it is, all on the computer, and that's going to look good before the committee. And what's
Also,
the
that
number
we
one?
can, also
go
the
ahead.
lawyers and they can keep their detailed records of all the communications that have happened within the case. So it can also be used as a evidence, during your professionalism for the case, or if you want to show it to someone, you can always have it at hand. So that is like one of the best things that our clients have also said.
Well, let me ask you something, and I don't know this because I'm not as familiar as you are with my legal software.
Awesome.
But is it something that if I make a notation that on January 10th, 2020, I had a conversation with somebody, okay? Is that something that's going to be marked that it actually was in that date? Or is it something that, hey, now that I got this complaint, can I just add that into the computer and say it was on? Is that something that's going to show or not?
See, I've been using it. So what I do is I pull up the reports. So through the reports, you can get an entire report when it was created and everything. So you can give the exact date and give it, to anyone you want, including your client in such cases.
Okay, so that's good. It shows when it was created. That's very important. So
everything comes with a timestamp. Everything comes with the timestamp, whatever conversation and notes you're having. So
Right.
Everybody is aware of when that has happened.
Right. So that's excellent, actually. That's very good. Okay. What is the number one way to lose your law license? Okay, steal money. Okay.
Escrow.
If you steal money from your client,
Escrow.
you're going to lose your law license. Almost guaranteed. Okay.
Direct resignation from the
number of
practice of
learnings.
law.
I hope people are learning, sir. They're just having
Okay. Can an immigration client report me to the committee if I lose the case? Well, first of all, keep in mind that unfortunately, lawyers are second-class citizens. Okay, so they can any of your clients can report you for anything, and obviously, if you lose the case, they're not going to be too happy, and they can certainly report you. The question is it going to be a valid claim? A claim that's going to be actually showing that there's an issue there that could be raised in the grievance, or just that you lost the case. People lose cases, sometimes there's not enough evidence, and sometimes the judge rules against you. Hey, I lost cases and then we won them in the BIA. And if you look through the BIA, you'll see that cases went to the Second Circuit here and got reversed or got sent back. So, but yeah, of course, a client can always file a grievance against you. Okay, it's the merits of that grievance that you have to be concerned about.
So it also brings me to a very important thing. So like Mr. Joe also said that mentorship and, taking an advice from a lawyer is fairly important for every person who is fighting a case. So that is the reason we are providing a free legal mentorship for people who sign up with NYList or subscribe for our newsletters and all. So we provide free legal mentorship from our legal panel. And I hope that helps our attorneys, whoever
also, I'd like to mention that Joe's also on a legal panel if needed. If you contact us, we can, also refer you to Joe anytime. And he's a great man. And my legal software, and I strongly recommend Joe.
Thank you very much.
Fantastic job.
Yeah.
And as you can see that the benefits of, NYList are good. So even if you're a new lawyer, don't be scared to practice law. But remember one thing, according to some recent cases which I cited, immigration lawyers are held to a very high standard, especially because they are dealing with foreign nationals. And the case for that, which I mentioned, a very important case is Aris versus Mukasey, 517 F3D 595, Second Circuit 2008. 517F3D. That's important. So your next question, Joe, please proceed.
What constitutes neglect in immigration cases? I think we've pretty much mentioned these things. Okay. Not following the right relief for your client where it's really obvious that certain relief's supposed to be, not advising your clients of dates, not coming to court. Those are things. What is the most common disciplinary issue faced by immigration attorneys? Okay. Now that could be anything, but from my experience on the committee, like I said, I was on a committee for 8 years. My recollection is a lot of these immigration cases were cases where the lawyers took money and didn't follow through, weren't too diligent in following through, or never filed the cases. A lot of them have to do with that. I didn't see, and I know they exist, but I didn't see that many cases where the lawyer was, he did something wrong at the hearing. Okay, but we had some cases where they said that did happen, and those were the Lozada type cases. And as I told you, the committee is aware of those cases. At least when I was on the committee,
Right.
we were aware of those cases and we treated them accordingly. And we always looked at them, with a grain of salt. Why are they making this complaint now? What are they saying? And then we look at the lawyer, and there we go back to proof and evidence, which my legal software, if I'm going to mention them and promote them, or any kind of software that's going to document the dates that you did things, is going to be evidence for you to protect yourself if there's a claim made against you. Okay.
Thank you. So a few important things. If anyone has to reach Joe DeFelice, the phone number is 718. Joe, your number, please.
718-261-3358.
718-261-3358. And his website is
DeFeliceLaw.com.
DeFelicelaw.com. And
Right.
if there's anything else, you can reach out to Anjali at My Legal Software, to Priyanjali or to Urvashi. Call the number and they will connect you with Joe. And we are happy to state that Joe will be kind of also with us. And if there are issues, he'll be happy to contact you through My Legal Software. You can call him directly either way. And we'll be happy to help you. And he's one of our members at this stage. So now, a very important topic coming up next week. Not next week, 2 weeks from now. And the date is, I would say 2 Thursdays from now. Look at the date, Anjali. And the topic is going to be complicated issues in PERM, PERM, Program Electronic Management System, which is the labor certification, and I-140 RFEs. I-140 RFEs and PERM, Program Electronic Management System. And this is great for employment-based immigration attorneys. 29th September, 3 p.m. Mark it on your calendar with Sonu Lal, who has done several employment-based immigration matters. He's very good at what he does. As you all know, we try to get you very good speakers, and definitely we screen our speakers before we get them, as you can see. And if you want to speak, or if you want to have a demo for My Legal Software, you can call Anjali and let her give the closing statements before we see you next week. Your closing remarks, Anjali. Thank you. A big thank you to Joe DeFelice. And as I said, this video will be available. And if you like the session, please do not forget to share it with your friends and keep informing your friends and colleagues to join us, and also try to become a speaker if you're really good at what you do. It can be in immigration, it can be in bankruptcy, it can be in divorce, because I think My Legal Software has software for general practice lawyers as well as for immigration lawyers. Anjali, the floor is on to you for your closing remarks, and with a big thank you to Joe DeFelice.
Thank you, Nadish. Thank you to My Legal Software for sponsoring this webinar.
Thank you so much, sir. And it was a pleasure for all of us, even all the attendees who have been watching you. It was a great, knowledgeable session. I hope everyone kept a note. And like we said, this event was sponsored by My Legal Software. So My Legal Software is a legal case management software that is created by the lawyers for the lawyers. And over the decade of experience, all the team members have actually collected the feedbacks from the paralegals and from the attorneys on where they face issues during their sessions, during their case. And that is how we have come up with a 360-degree solution for the attorneys and the law firms to manage their cases in a better organized way. This is the way to go paperless, because in the coming time, or you might currently even face a lot of issues while handling the cases and the case notes, everything on paper. So My Legal Software provides you document management, client management, accounting and billing, case management, and every integrations, anything that you want to customize in the software, everything is provided by us. We have tried to cover every aspect of the software and the case management. Also, sir, I would like to mention that we provide a 14-day of free trial for people who are going to basically sign up this month. So we're providing a 14-day of free trial. You can simply go to the website, that is mylegalsoftware.com, and you can just start your free trial from there. If you want to take a demo, you can call us on our number 212-390-9493. You can alternatively drop us an email, or you can directly go to the website and schedule a meeting. The link is fairly simple. It's just mentioned right in the front. Also, if you have any questions about anything that is related to the legal, you can simply mail us at legalquestions@mylegalsoftware.com. So we would definitely get back to you as soon as we can. We'll be consulting our attorney panel, including Mr. Gehi, Mr. Joe, and a couple of other attorneys that we have. Sir, anything else from your part?
Thank you so much. In our law firm, we use it for immigration as well as for general practice, and both the, I think, even general practice lawyers can try it out, and even immigration lawyers. And if they feel it's a good software, they should go for it. And it's cloud-based, and that's what I like about it.
Thank you so much, sir. Thank you, Mr. Gehi. Thank you, Mr. Joe.
So 2 weeks from now, September 29, again,
It's
that's basically, someone could type the topic over here. The topic is going to be labor, complicated issues in perm and I-140 RFEs. So complicated issues, let me write it down, complicated.
Okay.
We'll mention the
Thank
details.
you all.
Yeah. We'll be mentioning the details on our social media channels. You'll be getting the emails about the next webinar, the newsletters. So thank you so much for joining in. Thank you, Mr. Joe. Thank you, Mr. Gehi, for being here.
Thank
See you
you.
in the next
Bye.
session.
Bye.
Thank
Bye.
you, everybody.
Thank you,
Bye-bye.
Nitish.
Bye-bye. Thank you.